I'm Rick Steele, and I'm going to talk to you about why it is so hard to transpose the GDPR to the United States. So, to understand this, it helps to step back and have an idea of the competing social values in the two jurisdictions. In the United States, we talk about having a liberty paradigm or a property paradigm where economic freedom is very important. And this is motivated by our Constitution created in an environment of British oppression of economic rights, where we see sectoral statutes around privacy. They arise in sectors such as education and healthcare that are transactional in nature. In Europe, there's more of a focus on a dignity paradigm or a rights paradigm, where the privacy law comes out of human rights under the Charter and the GDPR. And this is informed by European history of resistance to royalism and informed as well in the 20th century by abuse of information in fascist regimes. So when we talk about the need for adequacy, the GDPR requires that information where jurisdiction about EU citizens is received, there must be GDPR equivalent protections. And the United States has had trouble achieving that. There's a lot at stake with trillions of dollars in trade across the North Atlantic. The safe harbor framework under the GDPR predecessor regime was said to ensure US adequacy, but the Court of Justice in 2015 said that it did not in Schrems 1. The Privacy Shield successor regime in 2016 also failed in the European Court in 2020, and we're now under a third at bat for the data privacy framework enacted in 2023. So why is it so hard? There are some points of friction in US law around national security, judicial redress, non-commercial uses, and downstream control of data, and we'll have a look at those. So beginning with national security, the GDPR and Charter allow only necessary and proportional impingements on data rights. US national intelligence under the Foreign Intelligence Surveillance Act, or FISA, in implementing orders, allows warrantless and warranted surveillance. Warrantless surveillance is happening at border crossings, and we know now is happening in bulk. Snowden revelations told us about the PRISM and upstream programs. Under Privacy Shield, the United States promised to curtail its information collection at borders with filters around certain subjects, but they're still quite broad. When the FISA court issues a FISA warrant, the data collection occurs and the subject might not even know, so therefore might not know to object. There is limited redress then. Under Privacy Shield, a person was able to object to data collection to an ombudsperson, but the independence of that role within the State Department was questionable. Under the new DPF, there is a new executive order that has an oversight board to review intelligence agency policies, and the ombudsperson is replaced by a civil liberties officer and a data protection court. There have been efforts to reform FISA and limit its scope of permissible surveillance, but the bills called for domestic limitations only, and neither has passed. There's a good deal of criticism around the US DPF approach. There are still hundreds of thousands of incidents of data collection. We know that there have been domestic surveillance incidents, seemingly politically motivated, such as against Black Lives Matter protesters. The United States still does not concede that there are privacy rights owed to foreign nationals, and the CLPO and DPRC do not afford true judicial redress as they are administrative entities. US persons counter that there are surveillance methods in play by EU member states that are just as intrusive as the US intelligence framework and are not held accountable under the GDPR. With regard to redress, a complaint against US public sector surveillance can take place through a DP or Data Protection Authority under the DPF system, but that goes again to those administrative entities, the CLPO and the DPRC. Respectively within the National Intelligence Directorate and the Attorney General's office. In the private sector, corporations self-certify their compliance with the GDPR, and a complainant's first stop is with the corporation itself, which then is supposed to investigate and provide redress. A claimant may opt into binding arbitration, which is ultimately backstopped by the Federal Trade Commission that can enact civil penalties. But again, you don't see judicial redress, and there's some controversy around the FTC's willingness to engage in enforcement. Everything we've talked about so far on the US side is just about commercial transactions, and the GDPR is not so limited. It applies to persons vis-a-vis other private persons. And this is consistent with the idea that there is no state action doctrine per se in European law. Human rights can be enforced against other persons. And when there are competing rights, they're subject to some kind of balancing approach. US federalism is rather different. Privacy in the dignitary sense is enforced through state law, not federal law. And congressional power is widely limited to commercial contexts under the Commerce Clause. Congress has some power to regulate with regard to civil rights under the 14th Amendment, but it simply isn't clear whether privacy regulation qualifies. So when we look at downstream control, you can really see the rights and property paradigms come to the fore. In the US property paradigm, data rights or data interests are something that can be alienated. I can give my data to a web service provider, for example, and it now owns that data, just as if I sold a piece of property. I no longer have control over it. In the rights paradigm of the EU, my interest in that data flows with the data. And so even though I give the data to someone else, I have a continuing human right that has to be respected in how that data is used. So when we look at the US First Amendment rules, we see these paradigms further expressed. So the First Amendment holds that there can be no civil or criminal liability for republication of truthful information lawfully obtained, and that creates a problem for the downstream regulation of information. The rule is not absolute. We have a privacy disclosure tort, but it's not clear whether the courts will engage with more departures from the rule. The secrecy paradigm, so termed by Professor Daniel Solove, holds that information once disclosed can no longer be secret. That also is consistent with the property approach to information. But we do see some appetite for widening the circle of what disclosure means. So, for example, in the healthcare context, I can share medical information with my doctor and even with my insurer without necessarily forfeiting my property interests, and my privacy interests. We'll have to see what happens with the data privacy framework. It has been challenged in European courts by NOYB, the Max Schrems organization, stands for None of Your Business. The website has terrific resources on privacy and accountability. And then the data privacy framework has its own .gov website where you can read more about it. Thank you for your attention.